Good afternoon and welcome to the Baylor Law Executive LLM and Litigation Management webinar. We've got a great series of topics today and a wonderful panel to discuss them. As you know, the Executive LLM and Litigation Management is a curated series of courses designed for practicing attorneys who want to be more efficient and effective in their handling of portfolios of litigation, complex litigation, and even individual cases. We're so pleased today to have a panel of true experts in e-discovery to talk about e-discovery in 2021, 2022, acting competently, and avoiding sanctions, which seem to be the subject of many of our cases. Professor Chris Schultz, who teaches our e-discovery course and is actively involved in the Sedona conference, joins us. Kathy Owen Brown, who is a real expert on the AI implications of e-discovery, as well as the ethical issues from her time with the Texas State Bar's disciplinary work, also joins us. Patricia Diaz-Rodriguez, one of our graduates from the program, and with Ankura is here. And last but certainly not least, we are privileged to have Judge Xavier Rodriguez join us. As always, I could take our entire webinar talking about the credentials of these panelists, but I'd rather let you read those for yourself while we dig into the topics. So, Chris, there have been a couple of interesting e-discovery cases that have come out, both from Texas state courts and on the federal level. And it's interesting to me because one of those cases involving the Sandy Hook Elementary defamation action, we're starting to see some verdicts roll in on this. Talk to us a little bit about the Heslin versus Jones case, if you wouldn't mind.
Well, Liz, thank you for having me today, and a hearty welcome, of course, to everyone watching the webinar today. Let me go ahead and share screen. If you're like me, I'm a visual learner. I think a lot of lawyers tend to be, and I promise this will not be death by PowerPoint, but I've got just a few slides that will locate these cases we'd like to talk about today in space and time for everybody. By the way, can everyone see the PowerPoint splash screen? Great. All right, let's move forward. It is remarkable to me that it feels like yesterday, but the 9th anniversary of the Sandy Hook tragedy is coming up in a little less than a month. It'll be 9 years in December. And as everyone on the call, the Zoom remembers, we lost 20 elementary students and 6 adult staff members during this shooting in Newtown, Connecticut. Alex Jones and the InfoWar family of companies, which happened to be headquartered down in Austin, very shortly after the tragedy started a series of, and by the way, for those that perhaps do not know, he's a conservative provocateur, right, down in Austin, started a series of statements that the children weren't actually killed, that they were crisis actors and actresses, that it was a false flag event designed to help spur, greater gun control in the United States. Not surprisingly, in 2 or 3 cases in Texas, which is where Jones is located, and 2 or 3 consolidated cases in Connecticut, where the tragedy occurred, multiple defamation cases. There were other causes of action, but primarily defamation cases were filed against Jones and his closely held companies. Now, as Liz mentioned, this past Monday, so talk about ripped from the headlines yet again, 2 days ago, in Connecticut, we received yet another default judgment against the Jones family of companies. And the defaults occurred, by the way, these were preceded back in September by a series of defaults that occurred down in Travis County. We'll talk about these judges here in just a moment. in each of the cases based on what the judges have called egregious discovery abuse. If we happen to have colleagues from Travis County on the call today, you may know the Honorable Maya Guerra Gamble, our judge down in Travis County, who has 2 or 3 of these cases, issued her nuclear option death penalty sanctions against defendants back in September, and the Honorable Barbara Bellis, the judge in Connecticut, who just did the same thing this past Monday. And of course, you can see that final bullet. These cases no longer will be tried on the merits, but instead in 2022 will proceed to trial for damages purposes. Liz, I promise a few more comments. Heslin v. Jones, I won't read all of these comments that you can see on the screen. Suffice it to say, none of us want to see comments like this about our conduct as outside counsel or our client in any type of order or written opinion. I will point out the final one because there's a word in it that you don't hear every day. Quote, defendants have shown a deliberate, contumacious, don't hear that every day, and unwarranted disregard for this court's authority. And I think when we think about Judge Gamble, that was really the crux of the reason that she went to the nuclear option here. Multiple orders on multiple motions to compel that were simply ignored by the defendants over a span of many years. And eventually enough was enough. This is also interesting in one of the related cases here in Texas. And by the way, just to be clear, as Liz mentioned, all of these are state law cases. If you're primarily a federal practitioner, as I am, we're going to be talking about a comparison and a contrast with the federal rules here in just a moment. But I thought it was interesting in this related case in Texas, the Posner v. Jones case, Judge Gamble set out the various remedies that are available in Texas Rule 215 and had check boxes next to them. And with perhaps showing a bit of her ire, a great big Sharpie mark, a huge X in the remedy that she was choosing, chose, of course, you can see what I've listed here, judgment by default against the defendants, as this court has considered lesser sanctions and determined that they would be inadequate to cure the violation in light of the history of defendants' conduct in this court. And of course, the reference to 215.2, failure to comply with an order or discovery request, which again appears to be really the nail on which Judge Gamble is hanging her hat. Finally, take a look at what Judge Bellis in Connecticut had to say. And I liked this quotation a lot because like Kathy, like Patricia, I am guessing that all of us have had to say this to our clients many times in the past. And it's this concept that the courts and the federal rules of civil procedure or the Texas rules of civil procedure do not require perfection, but let's see what they might require. Neither the court nor the parties can expect perfection when it comes to the discovery process. What is required, however, and what all parties are entitled to is fundamental fairness, that the other side produce that information which is within their knowledge, possession, and power. Sometimes we render that possession, custody, and control, right? And that the other side meet its continuing duty to disclose additional or new information when it is incomplete or inaccurate. Why this outcome? This is the final slide, and then we're going to, I'll push it to the panel to comment. Why this outcome? Was it the judges? We're talking many, many years, many motions to compel, many orders on those motions to compel, which were then just ignored by defendants. Is that why we finally got here? Was it state versus federal law? We talked a little bit about 215 versus its close analog, not verbatim analog, but close analog in the federal rules, Rule 37B. Is that how we got here after so much time? With 37E, of course, in the federal system, the nail that we hang our hat on when it comes to spoliation of evidence, would that have made a difference? The intent to deprive standard in 37E, could we have gotten to a resolution faster very interesting question. And then, of course, perhaps slightly beyond, Liz, the purview of this webinar, but the First Amendment considerations and overlay in this case may have also, given rise to why it took so long for the straw to finally break the camel's back, so to speak. So let me stop sharing.
I would add one more point to that. Texas is relatively newer to e-discovery than the federal system. And I think the other aspect that might come into play is that our judges are working their way through what has been. We don't have the sort of procedural framework yet that you have in federal court with e-discovery. And I think you also have that natural reluctance of a trial judge to deprive a litigant of their day in court, especially until they are confident that, and Rule 215, you have to have considered lesser sanctions, or you can't impose death penalty sanctions. And you've also got to find out who the bad actor is. Is it an incompetent attorney? We'll talk about that some when it comes to DR distributors. Is it a bad faith litigant who's hiding materials? Is it a joint venture between the attorney and the litigants? Judge Rodriguez, I'd be very interested in knowing from your perspective how this might have played out differently or the same were it in federal court, to Chris's point on the slide.
So, I think oftentimes people think of discovery abuse and they in federal court think of 37E and spoliation, or in state court here in Texas, we think of Brookshire Brothers and the case law that's developed there. And many practitioners forget that there's other parts of both the federal rules and the Texas rules that implicate the opportunity for the court to award sanctions. And so Chris mentioned 37B boy in his slide. And then there's other parts of the Texas rules of civil procedure. And so at some point, there's got to be proportionality into what sanctions are awarded against a litigant who fails to produce the discovery that's required. But at some point, and in this case, the judges both in Connecticut and Texas had reached that point. You can't allow conduct to go unpunished. And so the punishment came. And the punishment, I guess the point I want to raise is the punishment can come in any number of different formats, not just spoliation. And then both in Texas and federal court, the court has its inherent authority to establish and enforce proper conduct by the litigants. And so that's even apart from the rules. There still has to be proportionality in what we do. Default judgment should be the last sanction, but it is a tool in the kit.
Well, and I think that's a great point. And you know what, I misspoke about the Texas rules. They were actually in place in some ways 7 years before the federal rules were. So pardon me for that mistake. But I think it's an interesting point how we're handling this. We have a question from one of our watchers who asked, just for his own edification, would it be possible for Alex Jones and the defendants to file an interlocutory appeal on this issue? I know my law professor answered, but any of the panelists want to weigh in?
So I don't believe it's an interlocutory appeal. I think one possible but unlikely avenue may be mandamus, saying that the court reached an improper decision there. But generally, mandamus is, well, they used to be hard to get. I'm not sure they're not that hard anymore. The Texas Supreme Court's been a little more lenient in allowing mandamus. But I think the argument would be, if I was on the other side, that Mr. Jones could wait until such time as the full and final judgment of any damages were awarded, and he's got an opportunity to appeal at that point.
Yeah, he probably has an adequate remedy on appeal. The only other way I can think of is Texas Civil Practice and Remedies Code, Chapter 51, permits interlocutory appeal if everybody agrees that it's an important question of law, and it would significantly shorten the litigation to get that question of law. Here, if all you're doing is having a trial on damages, I think it might be difficult to meet that permissive standard. And so for our audience, I think this is one that you'll probably see on a traditional appellate mechanism as opposed to an interlocutory appeal.
Liz, I just want to interject real quick. Just if it going up on appeal, you read these cases, and at least I'm like, how on earth could they make that mistake over and over and over again? You're like, is this a bad facts make bad law type case? What's going on? I noticed a large multi-district litigation that there's more to the story than's being reported there. But if that's going on, if you're not in front of a very fair jurist like Judge Rodriguez, who may not be hearing all of your story, that's all the more important to document everything you do and have it documented well, because maybe you did do the right thing, but you have no way to prove it. And so not knowing what kind of judge, not knowing what might come down the pike later on, it's very important as part of your duty of diligence as a lawyer to document everything that you're doing all the way. Because it may have been this bad, it may not have been this bad, but we'll never know because this is the record that we have.
Kathy,
I have to
point that comes up in DR distributors, and let's talk about as a group, what do you need to be documenting and why?
Yeah, Liz, I was going to say exactly that. When we get to DR, which we will here in a moment, is it page 240, something like that? We finally get to a discussion of the importance. Judge Johnston expressly talks about the importance of documenting everything. Kathy, it's an excellent point. I say to my students, I can't remember what I had for breakfast this morning or yesterday, right? Let alone trying to back into the propriety of activity, in some of these cases, 2.5, 3 years prior. So it's absolutely present there. And something, again, to Kathy's point, that's remarkable that it does not appear, at least in DR distributors, not unclear what happened with documentation in Jones, but at least there, that the documentation efforts were just either non-existent or very minimal.
Patricia, you are working with Ankura and people consult you specifically for expertise. I mean, the ABA model rules require us to be technologically competent or to know that we're not and to hire somebody who is, and that's usually the hat that you wear with Ankura. Talk to us about how you avoid some of the pitfalls that we were seeing described in Heslin and how you can help with documentation and process.
Yeah, I mean, thanks for having me on. And during the prep call that I had earlier, this particular case had come up, and even what Kathy had mentioned about having documentation. Now, I don't know 100%, like she said, we only have the record, but it didn't appear as though there was any vendors engaged in this matter. So all of the documentation and all the videos that could have been collected, preserved, and essentially duplicated, there's no record of that. So that's where we come in, experts, vendors, support, essentially from this side, where the client, we're a conduit between the client and the firm, right, or the counsel. And so we can only do what you guys allow us to do or what you tell us. If you don't bring us in and say, hey, this is what we have, this is what we're looking for, like you said, you don't have to be technically savvy, but you need to know exactly, you need to tell us, right, at the very least, where the documents are, where the data is, who has access to it, and be very full disclosure. That's the only way that we're actually able to help in protecting you from these sorts of sanctions where things are spoliated or deletion of things that we could have preserved and essentially been able to back up when it was realized that this information was lost.
Judge Rodriguez, I know one of your favorite parts of being on the bench is hearing parties squabble over discovery disputes. How does it help you in sorting out these issues, because people come to you with soup to nuts. What are we going to discover? Are we using search terms or AI? Have people complied in good faith? What helps you when lawyers come in and say, but I've got this, in making decisions about, is it inadvertent? Is it sanctionable? Have we complied with the scope? Help us help you.
So it helps if the lawyers are prepared. And so that sounds like a logical starting position, but it's not always where we begin. And so I think one of the major failures in litigation in achieving efficiency is the lawyer just, for whatever reason, and it could be client, some clients hoping to achieve early settlement, I believe, instruct the clients, don't do anything. We don't want you investigating. We don't want you doing any prep because we're going to try to settle. But then again, judges, we only see the failures, right? So when that happens and there is no settlement, then we have to deal with the failure. And another part with that strategy I don't understand is, how can you settle when you really don't know your facts? I mean, how is that a sound way of going about your business? And so I don't understand that philosophy, but let's take bare minimums. At a minimum, the lawyer should be able to converse with his client about, okay, who are the key custodians that we have to deal with? Where's the data resident? How is it maintained? And so you have to have an understanding of your client's data. Then you should, in state court in Texas, we don't have an obligation to meet and confer, but there is that meet and confer obligation in the federal system. And so you should be meeting with your opposing counsel to try to talk about the claims in the case, what discovery is going to be required, try to set parameters on the discovery. Is this something what we can put time limitations on? Is this something we can negotiate with what custodians we need to get data first? Do we tier discovery? And so tiering doesn't always mean efficiency. Tiering could actually be bad. So we generally go to tiering or phasing, but it could actually lead to more expense in the long run by tiering and phasing. So you have to have an understanding of whether that makes sense. So with that background, I think you can avoid a lot of mistakes, and maybe we can talk a little bit about DR distributors at this point. And let's go back to Jones as well, and for this contrast. So in Jones, we really don't know, except what's being reported in papers and media, because in Texas, trial judges don't have to issue reasoned opinions on what they did. So we don't have the full background about what was before the judge, what was the history of the conduct. In federal court, we do have to issue reasoned opinions. And here we have two very stark scenarios. We have 0 pages and we have 250 pages. There's got to be some better
proportionality.
Yes. And so DR distributors at bottom, the facts, the client's being sued. It doesn't really matter for what. We don't have to go into those details. Client's being sued. The client tells his lawyer, here's 4 hard drives of information. Everything you need in this case is on these 4 drives. And the lawyer just takes the 4 hard drives and believes his client and doesn't do any further investigation. It turns out a couple of years later that the client knew all along that the client had been using Gmail and Yahoo Mail accounts, and those are cloud email systems, right? So those emails were not being captured on those 4 hard drives. The client knew that at the time. He knew his lawyer wasn't understanding that, and the client probably knew that the lawyer was sending it off to the other side incomplete. Why it took 2 years to figure this out is beyond me. I'm not sure what was going on with the other side as well, going, hey, we're missing stuff perhaps. But it took 2 years before it comes up to the attention of the court. And it took a little while. Here's I guess, another failure of the lawyer. once the lawyer catches on, and it's way too late, but once he catches on that there's emails out there, he takes 3, 4, 5, 6 months before he notifies the other side or the court of the deficiency. And of course, by that time, we've got spoliation issues. So number one, you really do need to understand what your clients have. And number two, when there's mistakes, and there's going to be mistakes, you really need to fess up early on that mistakes have occurred rather than waiting, because waiting normally doesn't help. So it results in this 250-page opinion. I'm critical of its length, of its repetitiousness. It's a treatise on e-discovery when it doesn't have to be a treatise on e-discovery, but it does raise the interesting point about ethics and what's required of attorneys and who's responsible for failures. And I'll stop there just to let everybody else comment on that.
Liz, I have to go backward. Excellent comments, very good. To an early comment by Judge Rodriguez, you think about practical, helpful pieces that those lawyers and DR distributors could have used. What about a checklist, like something like the Sedona Conference Jumpstart Outline, right? If they just would have had a copy of the Jumpstart Outline in front of them, many of these very basic left-hand side of the EDRM failures, it kind of reads like a basic failures course, right? Could have been avoided as they went through the checklist with regard to identification, preservation, and collection. So, you know, to the extent that participants on the call are looking for a practical help, and by the way, Judge Johnston calls out the Jumpstart Outline as something that would have helped these negligent lawyers, incompetent lawyers, you know, however you want to describe them.
Judge Johnston calls out every secondary source available.
And that is why my second point, it is ridiculously lengthy. It is a godsend to those of us in legal education because it's now required reading. Judge, I'd like to hear if it is with you at St. Mary's. It's now required reading for my students here at Baylor. Well,
with all due respect to Judge Johnston, that case will not be a required case for my students to read.
Love it.
I have summarized that case, and I could summarize it in words in probably 10 pages.
Yeah, yeah.
Well, I think your point is an interesting one because one of the complaints that the judge has is that lead counsel, and by the way, there's like 20 pages of who was lead counsel and why, talks about the fact that the lead attorney, even though a very experienced, well-regarded trial lawyer, was oblivious to what data existed, how it was kept, didn't understand or appreciate the difference between cloud-based data and data on servers, which again, if you don't know or understand, certainly is when you call Patricia or someone similar. I want to loop to Kathy and Patricia, both Patricia to talk about how you can come in early, but Kathy to talk about some of the innovative work DLA Piper is doing with artificial intelligence and predictive coding in how you figure out what exists and what doesn't. So maybe we can start there and then flip to Patricia.
All right, yeah, I love to talk about this, and I could take up the whole time, and I promise I won't. But and we keep talking to other people. It's one client that we're working with that we're doing this, and there really hasn't been that much adoption yet, which to me is so logical. How it started out, I was working with a client, and they acquired a company, and one of them had extremely broad legal holes. The other one sent out very narrow legal holes. And we're like, you know what we need should be somewhere in between. And they were already very actively using AI to help with, there is manual part of document review, but using that to get the cream of the crop to the top, and not to go into all the technology of that, but we're like, there's got to be a good way to use technology to do this in a more defensible manner. And so what we have started doing is that we find a core group of custodians for the issue. It could be between 5 or 10. We pull their data out, And actually this for everyone out there, which it seems like it's almost everyone now, who is in a Microsoft 365, you can actually use Compliance Center if you have that license to start doing analysis. And we look at that, we apply search terms, and we look at that email and then see and analyze who is sending the email that is relevant. And, is that somebody I've identified? And if not, just keep pulling that. And as soon as we get our core group, we send the whole to that group. And then we're using the analytics of who is involved in the conversations, not receiving, but actually sending or authoring documents, and use that to keep making our scope bigger. And it gets pretty quickly, you figure out you had it. It's not replacing interviews. We're still interviewing people to find the right people, but it's, when you can go into a court and say, Your Honor, this is how we scope this. We use the data to tell us who was sending it. And usually you get to a point, it seems to often be for some reason 50 emails that you're sent in it. But then after our production is done, and I can't help but think that in DR distributors, if they didn't do something like this, they would have ended up with a better result. We look at the data we've produced, who sent the hot emails, who sent the most emails in the data that was actually produced to the other side, because that's where the other side is going to look at what you gave them. Oh, wait, look, you haven't given me anything related to this person, and look at the stuff that they're sending. So we actually look at our production set, and again, use artificial intelligence to tell us where the significant work and communications are going on as a final cleanup. If they had looked at, I'm guessing, I don't know, but if they had looked at the email in DR distributors, they would have probably seen Yahoo and Gmail mail for their key people and know that that's a potential source. If they should have asked the question to begin with. Frankly, in my mind, they should have had a company policy that you don't use personal email accounts to send work email, and that makes that a whole lot easier, but that's another aside. But
observed more in the breach, Kathy. Often observed more in the breach.
That's right.
And Kathy, I have to say, I think you're giving more credit to outside counsel in DR than maybe should be given, because, and I think this is one of the reasons why we don't have the nuclear option. We don't have a death penalty sanction coming out of DR, because they didn't seem to realize that the Yahoo email and the Yahoo chats and the GoDaddy email were stored almost like a software as a service in the cloud. They had anticipated that all of that would have been preservable and collectible and identifiable, right, behind the company firewall on the company servers. And that's just a fundamentally incorrect assessment. Again, had they done a proper client interview with the Jumpstart outline, perhaps of the IT professionals, right, that were managing those systems, they'd have known that, or they should have known that. So I think maybe you're giving outside counsel perhaps more credit than they would do in DR.
But I don't think they looked at the data they had. I mean, you look for data gaps. You mean date range gaps. I mean, you need to look at what you've turned over. At the eye that. If my opposition is going to look for sanctions against me, use the data, use the technology to figure out where I have gaps, and then ask the questions of the client. Maybe for some reason they don't have data for that time. Maybe they switched from one email service to another and didn't migrate email. There could be a lot of answers to the questions, but look at the data and let the data tell you what the questions should be, and follow up on that before you're in front of the court on the spoliation motion.
Yeah.
One thing we haven't mentioned is, so the ABA on the model rule of the duty of competence 1.1, comment 8 says to maintain requisite knowledge, skill, a lawyer should keep abreast of changes in the law, including the benefits and risk associated with relevant technology. Texas, we've adopted that now as well. In our comments, California a few years ago actually laid out various standards in a advisory opinion about what that duty of competence looks like. And so they're very specific. Here in Texas, we haven't reached that kind of specificity. And so there's a real lack of understanding, how technically competent do I have to be, and what does that mean? And so we're seeing examples of just where these failures can lead, but it's a very slippery slope, right? As technology changes with every new app that's put out. We're lawyers, we're not software technologists. And so at some point, how do we keep up with it all? I think the one thing I would like people to take away is don't bury your head in the sand. That's not an answer. Just saying, oh, this is beyond me. I don't understand this, so I just won't deal with it. You need to be asking questions. Even if they're stupid questions, ask questions to your client. Where is your stuff? Who keeps that stuff? Do you have an IT department? Who can I talk to understand this? And then figure out what do you have and who do you maybe have to align yourself? Is it an outside vendor? Is it another lawyer who better understands this to meet your ethical obligations under Rule 1.1?
Yeah,
Wait,
excellent.
you're the outside expert who probably has more technological knowledge and savvy than all of us. What are your thoughts?
Is that directed to me?
Please.
Sorry, I didn't hear the beginning. I mean, I think, very similar to what Kathy said, if they had just done some sort of even device collection, everything would have been found. Everything, most of this information, all these emails would have been found if he knew well enough to ask for laptops or, desktops. And then you would have noticed you had all these, other email accounts. So, similar to what Judge Rodriguez said, if you're not fully tech savvy or really know exactly what you're doing, aligning yourself with the correct people who say, hey, okay, well, that's great that you got these hard drives, but what about everything else? Did you check the cell phone? Did you check, all these other areas in which data is currently stored? We're living in a very tech friendly environment, right? Obviously more so now with COVID, and people are using cell phones and private phones and emails and Zooms and, chats and Slack. And so you have to really ask these questions. So some of it is a bit of common sense, to be honest. And some of it's, if you don't know it, ask somebody who does know it. Like to Judge Rodriguez's point, they might seem silly questions, but some of this would have all been avoided with very, very little diligence, is to saying, hey, do you have any laptop? Do you have a laptop? We're gonna image it and see what you have. And likely that first image would have shown these other accounts of these cloud-based emails.
Patricia, we've been talking about things that are fairly easily recoverable, emails and text messages and all. What is ephemeral messaging and how does that play into the data collection? Where can I find things?
So that's a great question. I had a really good conversation earlier with Professor Schultz about it. And so ephemeral messaging is essentially self-destructing messaging. It's normally mobile device to mobile device. And it's Snapchat, right? I send you a message and it will self-destruct within either minutes or seconds after the recipient reviews it, right? And that's obviously creates a massive problem for the purposes of collection and preservation. Currently, it's practically impossible to collect and preserve self-destructing messages. So, it has created a large pit, circle pit hole for people to continue to use these apps and then have all their communications kind of delete. Going through some of the cases that we've looked at today, there's very, very little reason for a business to use these sorts of messages. And it's really hard to justify it, right, in front of a judge if you have nothing to present for e-discovery purposes because you've been using apps that self-destruct.
Well, but Patricia, I think that people who have global clients use applications like WhatsApp a lot because you can call, you can message, you can do that. I mean, if I'm right, isn't WhatsApp ephemeral?
So WhatsApp is an encrypted application, right? Which is a bit different. It doesn't self-destruct. There is a feature on there that will allow you to set a self-destruct mode, but that's typically 7 days. So, you have enough time to go in and collect and preserve within 7 days, unless you set your phone to like auto deletion, which also looks very bizarre from an attorney perspective, why you have auto delete on if we're telling you if there's a litigation hold. Obviously, you're not supposed to be doing that. But a lot of those other apps like Slack, that they're encrypted, they're not self-destructing. So you can still recover the messaging.
And Liz, I want to pick up on an excellent comment that Patricia made, which is, as we give counsel to clients, when is it appropriate to use something like a telegram, right, which really is a self-destructing, this mission, should you choose to accept it, right, type scenario, for those of us who are old enough to know what that means, versus something like a WhatsApp, which really is an encrypted, secure communication with the option to delete. I've got colleagues, and Patricia, I'd love to get your thoughts on this. I've got colleagues that use the encrypted WhatsApps of the world when their client has been hacked, when their client has been the subject of a ransomware attack, and they feel it's the only viable way, because the company's systems have been, compromised, that they are able to securely communicate with the IT pros at the company to try to remediate the issue. That feels very different to me than, for example, what was happening in some of the cases we can talk about here, where the IT pros switch over to a self-destructing text message system in the midst of discovery. But Patricia, do you have clients that play it a little easier on the cybersecurity side of the ledger?
I mean, I think encryption is just smart, right? It's a smart thing to do, especially if your systems have been hacked, you're a bit more exposed. That is very different, right? I think using destructing messages has a very different intent, right? I don't want you to see what I have ever, versus I want to preserve, our privacy and make sure our information is not being leaked. I think that's very different. I think we talked about it before, and the idea of how you can possibly ever extract or preserve self-destructing messages. There are ways in which possibly you can do it. Most of it is law enforcement. There's a couple of things that you can do. One is called a jailbreak or a checkmate of people's devices. It's incredibly hard. It's super expensive. It takes a ton of hours. So the cost benefit is very small. And I think as tech continues to evolve, we'll likely have to figure out a way that we can preserve this sorts of messaging, because more and more people are using it.
What a lot of my clients are doing now, well, number one, if you're not subject to a duty to preserve, you don't have to worry about those. And so they take care of that within the legal hold and start instructing not to use certain type of technology to communicate regarding the substance of the legal hold. Not on everything, but just the substance of the legal hold, to try to avoid some of the difficulties, the spoliation and different type things. And in fact, some of them have policies, they with their mobile device policies that they have, they talk about, do not use, your mobile device has all of these company apps on it, tons of things, and don't use your mobile device to communicate with somebody regarding substance of work issues on anything other than a company supported app, and take care of it that way.
Kathy, can you think, back to the early, can you think of a good business use case for the self-destructing? Would it be a merger, an acquisition? We're trying to keep things super confidential. And to your very good point, there's no pending litigation. There's no reasonably anticipated litigation. There's no regulatory reason why we have to preserve these communications. Is that where it would arise? Otherwise, my paranoia as a counselor kicks in and just says, it's best to just avoid it. But I'm wondering if you can think of, or if your clients have a bona fide, use case.
I'm conservative and old enough that I would just say avoid it.
Yeah.
But if there's no duty to preserve, and maybe, it's like it's been mentioned, they've been subject to attacks before, and it's
Right.
a highly confidential product that they're developing, or a technology that they're developing that they want to make sure that there's no way there's a hacker that gets in there and finds that information, something along those lines. But there's a lot of ways to encrypt other than just the self-destroying email, not email, but conversation apps to do that. So I'm conservative enough. The scary thing is, which is probably beyond the scope of this, is the ghost, your ghost technology and different things, where your employees just go off and start finding things and adding them to start using them so they can get what they want to do instead of, using your IT supported apps. And the other thing is it's very important, if possible, for the IT department and the legal department of a company to have good relationships with each other, so that IT will consult with legal if they're adding new technology, or if they're decommissioning technology that might be subject to preservation.
Yeah.
So I think what needs to be reinforced here for the lawyers is you really need to visit with the various custodians and key players. And how do you communicate? Do you use email? Do you use chats? Do you and go down some of the commonly used applications? And if you find out that they're using, now they're probably not, if they're going rogue, you're in a real quandary, right? So they're not supposed to use some ephemeral messaging device, but they are. And so you may not find out about it originally, but at least ask the questions. You've documented that you've asked the questions. Perhaps that'll preserve your client from getting worst case sanction scenarios because you were misled by a rogue employee. I've gone back and forth with a lot of people on the proper business use of this.
Yeah.
I guess I'm old school. I don't see it. Some people are convinced about it has a proper role. The only proper role we generally see it in the case law is antitrust and theft of trade secrets, and that's not a proper role. If you're going to use it, then there are device settings that allow you to make sure that they don't self-destruct. And so it's ESI. And so if the duty to preserve has been triggered, you have a duty to preserve those types of messagings as well. And so that's the quandary for the in-house and outside lawyer to monitor all this.
Well, and we wanted to spend a few minutes here towards the end talking about how do you avoid and mitigate against these issues. And I think it's important to remember that we still need to be good counselors to our clients. And when we talk about talking with them, so many lawyers are visual learners. There is something to be said for sitting down and saying, show me, pull up your desktop, pull up what you have. Let me see this, show me yourself, especially with key people. And then also advising them, I think, on routine destruction policies before there's a litigation hold, because when we're talking about cost, if I've got this many years of data versus this many years of data, because nobody ever cleans anything out, that's another issue. So I think that's another important aspect of it too.
Well, it is, Liz, but you predicate your whole question upon outside lawyers having that opportunity. And so many companies nowadays have taken so much of the discovery operations in-house that outside counsel is sort of barred from really doing anything. The case comes in, you're assigned as outside counsel, and you're presented, here is what we're going to pass on to you. And going back to DR, as much as I don't want to, the court in DR really goes after those lawyers for allowing self-collection by the client in the first instance. I'm not sure a blanket prohibition on self-collection is appropriate. There are some cases where self-collection by the client, if it's a sophisticated client, understands its obligations, you reviewed what they produce, you as outside counsel don't see any deficiencies, and so all that would be perfectly appropriate. A blanket no self-collection, I think, is inappropriate, but for some cases it could be. You don't ask the sexual harasser, for example, to self-collect. You don't ask the antitrust CEO who was involved in all the allegations of collusive behavior to self-collect. There's some cases that self-collection is wholly inappropriate. But there, like all cases, it's a case-by-case analysis. But I fully recognize now, especially for a lot of retail defendants, that outside counsel is at a real quandary to get involved, as you're suggesting.
Well, and there's a balance that has to be struck because Judge Johnston, and you're right, he is very he's anti two things. He's anti non-written hold notices, and he's also anti self-collection. And he cites there the Qualcomm v. Broadcom line of cases, and rightfully so. And yet, for the right client, supervised appropriately, that is still an option that, you know, the Cathys of the world and the Patricias of the world and others will still offer as appropriate. But I do think he was concerned by the Qualcomm line of cases in putting a pretty heavy thumb against self-collection.
So we're worried about efficiencies, though, proportionality, and the cost of litigation. And one thing that I am also critical of DR on is he takes the mindset established by Judge Shinlin in her line of cases. And Judge Shinlin did amazing early groundbreaking work in e-discovery. But frankly, the case is now outdated. And it's certainly outdated in light of the 2015 rule changes where we insert proportionality as more of a factor. And so we need to take into account all the economic aspects now in the proportionality analysis. And my problem with DR and a lot of other related cases, it still takes that old mindset and injects it into the current case without any really good recognition of what we were trying to achieve in the 2015 rule changes. And then the other criticism, just because you mentioned legal holds and written legal holds, yeah, it's always a good idea to have a written legal hold, but then it all is case specific, right? And so in DR, a written legal hold to who? The client was one person and he ran the whole thing. And so what, you're going to issue a written legal hold to your one client? That was, I think that was just throwing in the whole kitchen sink that DR did. But, is it a best practice? Yeah. But, like everything else, it was a little bit too much in that case.
Yeah, Mr. Duke is a Stanford educated economist. He's the president of this company. And yet I probably still would have given him, I would have talked it through with him. I still would have probably given him something in writing.
At least an email.
At least a confirmatory email.
So that way I have it documented that I did it. So.
Well, and isn't that really the point? The judge in DR Distributors is so incredulous.
Right.
That multiple conversations between attorneys, counsel, remember, it wasn't just the original firm. They affiliated other lawyers, people who were like, yeah, I became kind of concerned. And yet not a single lawyer was documenting these conversations. And it seems to permeate through the opinion to me that the judge believed they were a little disingenuous. Either that or just not the sharpest tacks on the bulletin board, that they literally didn't document what are vital conversations in the context of discovery and litigation.
Hey, Liz, before I forget, just for the good of everybody listening, if you're looking to start your research on ephemeral messaging, the granddaddy case, it's not that long ago, 2017, but you always think Waymo v. Uber. And so take a look at that, reach out to any of us. We'd be happy to talk that through, and then compare and contrast that with something like Herzig, that fast forward to 2019, Herzig versus Arkansas Foundation for Medical Care. And you'll see how the courts have wrestled with those issues. And also for the good of the group, if you're looking for a case to get started on some of these written hold notices issues that Judge Rodriguez just mentioned, you've got to start with, it's an oldie but a goodie, as he mentioned, the Zubalake line of cases from Shira Schindlin, now retired from the Southern District of New York. So.
And I will say, we had a request from an attendee, Chris, that your excellent PowerPoint slides with the summary of these cases be made available.
Absolutely.
We'll ask, as you get your follow-up email, we'll try to attach those PowerPoint slides as well, so you've got them.
Yeah, absolutely.
I'd like to go around and have each of you share a few thoughts as we wrap up on what are some specific steps, other than reading Chris's slides and the cases, to get better at this. Be more efficient and more effective, whether it's in the front end, early case assessment, litigation, hold, data scoping, all the way through. Give us your pearls. Patricia.
So I don't know if these are necessarily pearls, but I mean, I think that obviously as tech continues to evolve, the use of AI, the need for early case assessment, and it's no longer, you can't pretend anymore that you don't know, right? So if you actually don't know, you have to do something to help yourself, whether that's, you know, a CLE or reaching out to somebody, even within your own firm, and kind of partnering up to figure out how to go through some of these problems, because they're only going to continue to get either worse or more common for your practice. I think just continuously recognizing what you don't know and helping yourself is probably the best pearl that I can give, because as much as I don't practice in the same sense as I used to, I'm often surprised when people, you know, come to me as a consultant and they don't even recognize that they don't know, which is crazy. Because I'm like, you wouldn't be here. You wouldn't be asking me these questions if you had any idea, which frankly, like I'm saying, is what is the purpose, right? So at least coming to somebody with an expertise in a space that you don't have, at the very least, should be your self-awareness to get to that level.
Well, and Patricia, I think that's such a good point for our younger lawyers. If you're a younger associate and you are looking to add value, become technologically adept. You intuitively have spent more time with technology than most of us have, because it's been around in your life longer. And this, to me, is a place you really can add value. Be that person who understands and can help counsel within your firm. So that's an aside. Let's go to Judge Rodriguez. What are your pearls?
So, you know, we're so used to, as lawyers, to not doing any discovery and understanding the case for months after the case has been filed. And it's like, we think then we start the discovery process. And if we're going to reach just speedy and inexpensive, preparation really has to occur well before that time. As soon as you get retained, you need to start understanding the who has documents, where are they at, how much of it is there, so you can begin preparing already for knowledgeable discussions. And then also you're doing your client a service, because if you do that early case assessment, gather those documents early and find out that there are problems out there, don't you want to settle now before the problems get disclosed further? And so preparation is key.
That's great. Kathy.
Yes, you're kind of going old school a little bit. Cases come in, you're like, I have to find my witnesses, I have to do this, I have to do that. Take a few minutes to step back and look at the big picture. You know, look at the data you do have. You know, apply logic to what's going on, and don't just go through the checklist. The checklist is important, but don't just go through the checklist. I took over a case where a client had a $500,000 discovery sanction because they had not produced emails in the mid 80s. Guess what? The company didn't have email in the mid 80s, you know, but they didn't step back far enough to look, what's the logic, what's going on here. So document what you do. That's always the number one thing I say to do, but also look at what you have. Why isn't there email for this period of time? Why is, you know, apply some logic and don't just get paper out the door. And this is the last pearl of wisdom. Before you commit to produce something or to do something in a certain way, make sure it's technologically feasible, because there's many lawyers who have gotten in trouble because they made promises when they shouldn't have.
Well, and Kathy, I think your 2 points are so good, because what often happens, young associates, young lawyers drafting the privilege logs, asserting the objections, and no senior person who might have perspective, might see bigger picture, really pays attention early, so that you get into an issue where what have we objected to? What are we asserting privileges on that are ridiculous, and I think undermines your credibility with the court as well, and it's expensive for your client. Professor Schultz, wrap up.
Well, Liz, I'm always looking for a word of encouragement, right? We've just hit, what is it, over 100 people listening to this with some pretty egregious cases of malfeasance, right? What's the word of encouragement? I've got two. The first is from Judge Bellis, our judge from Connecticut in Sandy Hook. And if you'll recall the quotation, perfection is not the standard. Sometimes you come away from sessions like this thinking, oh my goodness, there's no way I can master this stuff. That is not true. Perfection is not the standard. Competency is, right? Not perfection. The second word of encouragement, Liz, comes from Judge Johnston, whether you love the opinion or you hate it. On like page 200 and fill in the blank, I'm not sure. He actually says, discovery is just discovery, right? Doesn't matter if it's digital bits or good old fashioned paper in banker's boxes. That EDRM that we talk about all the time is the same. To Kathy's point, take a step back. I don't care if you've been practicing for 3 years or 30 years, you know discovery, right? Affiliate with people that can help you on the tech side, but don't forget Judge Johnston's admonition to those counsel. Discovery is just discovery. And if you're practicing in the federal courts like they were, they should be able to do that.
The other thing I want you to remember from this webinar is that you now know and can use in a sentence contumacious.
Contumacious.
Want to be contumacious, which particularly when applied to a defendant is willful disregard. And that's where intent matters. Yeah. Intent is going to matter. Goodness, I want to thank all of the members of our panel for spending their time and their expertise, sharing their thoughts with us. This is such a rapidly evolving era that it's great to hear people who are on the cutting edge from such different perspectives. If you want more, if you want to figure out start to finish, how to be more efficient, effective in handling, managing your litigation, I encourage you to reach out to us and let us talk to you about this LLM and litigation management that we have here at Baylor Law. To all of you, have a great day. Thanks so much for joining us. We'll see you next month.